Tara lang.
Article 11. Justifying circumstances. The following do not occur any criminal liability. Number 1. Anyone who act in defense of his person or rights provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Number 2, anyone who acts in defense of his person or right of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relatives by affinity in the same degrees, and those consanguinity within the fourth civil degree, provided that the first and second requisite prescribed in the next preceding circumstances are prevent, and the further requisite in case the revocation was given by the person attacked that the one making defense had no part therein. Number 3, anyone who act in defense of the person or rights of a stranger provided that the first and second requisite mentioned in the first circumstances of this article are prescribed, and the person defending be not induced by revenge, resentment, or other evil motive. Number 4, anyone who, in order to avoid an evil or injury, does not act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than to avoid it. Third, that there be another practical and less harmful means of preventing it. Number 5, any person who act in the fulfillment of a duty or in the unlawful exercise of a right or office. Number 6, any person who acts in obedience to an order issued by a superior for some unlawful purpose. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. Number 1, an imbecile or an insane person unless the latter has acted during a lucid interval. When imbecile or an insane person, the law defines as a felony. Delito. The court shall order his confinement in one of the hospitals or any asylums established for persons thus affected, with which he shall not be permitted to live without first obtaining the permission of the same court. Number 2, any person under 9 years of age. Number 3, a person over 9 years of age and under 15 unless he has acted with discernment, in which is such minor shall be proceed against in accordance with the provisions of Article 80 of this code. When such minor is adjudged when such minor is adjudged to be criminally irresponsible, the court in conformably with the provisions of this and the preceding paragraph shall commit him to the care and custody of his family, who shall be charged with his surveillance and educations. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5. Any person who acts under the compulsion of irresistible force. Number 6. Any person with act under the impulse of an uncontrollable fear of unequal or greater injury. Number 7. Any person who failed to perform an act required by law when prevented by some lawful insuperable cause. Article 13. Mitigating circumstances. The following are mitigating circumstances: those mentioned in the preceding chapter, when all the requisites necessary to justify or to exempt from criminal liability in the respective cases are not attendant. Number 2. That the offender is under 18 years of age or over. 17 years in the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. Number 3. That the offender had no intention to commit so grave wrong as the committed. Number 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Number 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, delito, his spouse, ascendants, or relatives by affinity within the same degrees. Number 6. That of having act upon an impulse so powerful as naturally to have produced passion or obfuscation. Number 7. That the offender had voluntarily surrendered himself to a person in authority or his agent, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Number 8. That the offender is deaf and dumb, blind, or otherwise suffering some physical defect which does restrict his means of action, defense, or communication with his fellow beings. Number 9. Such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of the consciousness of his acts. Number 10. And finally, any other circumstances of a similar nature and analogous to those above mentioned. Article 14. Aggravating circumstances. The following are aggravating circumstances. Number 1. That advantage be taken by the offender of his public position. Number 2. That the crime be committed in contempt or with insult to the public authorities. Number 3. That the act be committed with insult or disregard of the respect due the offender party on account of his rank, age, or sex, or that is be committed in the dwelling of the offended party if the latter has not given provocation. Number 4. That the act be committed with abuse of confidence or obvious ungratefulness. Number 5. That the crime be committed in the place of the chief executive or in his presence, or where public authorities are engaged in the discharge of their duties, or in a place dedication to religious worship. Number 6. That the crime be committed in the night time or in an uninhabited place, or by a band whenever such circumstances may facilitate that the commission of the offense. Whenever more than 3 armed malefactors shall have act together in the commission of an offense, it shall be deemed to have been committed by a hand. Number 7. That a crime be committed on the occasion of a conflagration, shipwreck, earthquakes, epidemic, or other calamity or misfortune. Number 8. That a crime be committed with the aid of armed men or person who ensure or afford impunity. Number 9. That the accused is a recidivist. A recidivist is one who at the time of his trial for one crime shall have been previously convicted by final judgments of another crime embraced in the same title of this code. Number 10. That the offender has been previously punished by an offense to which the law attached an equal or greater penalty, or for 2 or more crime to which it attached a lighter penalty. Number 11. That a crime be committed in consideration of a prize, reward, or promises. Number 12. That a crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel, or international damage therein derailment of a locomotive or by the use of any other artifice involving great waste and ruin. Number 13, that the act be committed with evidence premeditation. That the craft, number 14, that the craft, fraud, or disguise by employed. Number 15, that the advantage be taken of superior strength or means be employed to weaken the defense. Number 16, that the act be committed with treachery, alevosía. There is treachery when the offender commits any of the crime against the person, employing means, methods, or form in the execution thereof, which tied directly and specially to ensure its execution without rest to himself arising from the defense which the offended party might make. Number 17, that means be employed or circumstances brought about which add ignominy to the natural effect of the act. Number 18, that the crime be committed after an unlawful entry. There is an unlawful entry when an entrance of a crime, wall, roof, floor, door, or window be broken. Number 20, that the crime be committed with the aid of person under 15 years of age or by means of motor vehicles, motorized watercraft, aircraft, or other similar means. Number 21, that the wrong done in commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Article 15. Their concept alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effect of the crime and the other conditions attending its commission. They are the relationship, intoxication, and the degree of instruction and education of the offender. The alternative circumstances of relationship shall be taken into consideration when the offended party in the spouse ascending descendants. Ascending descendants, legitimate, natural, or adopted brothers or sisters or relatives by affinity in the same degrees of the offender. The intoxication of the offender shall be taken into consideration as a mitigating circumstances when the offender has committed a felony in a state of intoxication. If the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstances.